We're live.
Thank you. We're now taking up S33, which is the annual miscellaneous judicial proceedings bill. I'm going to start with Annika Radke, the Deputy Commissioner of the Department of Children and Families, if she's here. If not, we can.
She's on Zoom.
Oh, okay.
Hello, Senator
Good
Steers.
morning.
I'm here. Good morning. How are you feeling?
I'm doing much better, thank you.
Good, good. Okay, so for the record, my name is Erica Radke, and I'm Deputy Commissioner of the Family Services Division of DCF. And I'd like to say thank you to Chairman Sears and members of the committee for having me here to discuss sections 18 and 19 of S33 regarding the language from the Juvenile Justice Stakeholders Group. My comments are pretty short today. The proposed language in Section 18 is essentially just to ensure that the language in the delinquency statute mirrors that in the YO statute, so that youths charged with delinquencies will have the same protections when engaged in using the YAZI risk assessment tool before merits as do youthful offenders. And in terms of Section 19, the proposed language there came from the delinquency statute, wherein the court can make direct referrals to barge as an alternative to probation. And we believe it's important to have that same off-ramp available for youthful offender cases as well. This language, the proposed change, would make it clear in the statute so there's no misunderstanding with respect to the ability in YO cases to make use of this community-based option as well, rather than just simply probation and oversight from DCF and DOC. DCF participated in the discussions regarding these sections with the JJSG because both Lindy Boudreau and Tyler Allen are members of that group and are very active. And based on the discussions that we've had with the group, we are in support of this language.
Great. Are there any questions for Annika? Annika, that was brief, and thank you very much.
Thank you. I'll stay on just in case there are questions later.
Okay, that'd be great. I think Matt Valerio is not available right this minute, so we're going to jump to William Gardella, Deputy State's Attorney in Chittenden County.
Thank you, Senator Sears, and I'm here also on behalf of the department as Deputy Luders Dumont was tied up, I believe, in a hearing in the House. Last time the committee heard from us regarding Section 17 of the bill, which amends the Juvenile Judicial Proceedings Record Statute, 33 VSA 5117. Both I and Marshall Paul from the Defender General's Office had expressed some concerns about the record statute overall, not this amendment that's proposed, but I did reach out to Attorney Paul after our last hearing with some suggested very small amendments to the record statute to resolve some of the concerns I think we both identified. I haven't heard back from him. I think he's unavailable as well at this time, but I can, if the committee would like, I can briefly walk through what the.
Yeah, it would be helpful if you would. My plan is to not vote on this bill until the week after town meeting. So there is time to process any future changes, but it would be helpful to get as many of them in place right now.
Okay. Thank you, Senator Sears. So what I proposed to Attorney Paul was the addition of 2 paragraphs to 33 VSA 5117 B1, which is the provision in that statute that lists the entities that are essentially entitled as a matter of right to access records in a juvenile case without there having been a specific court order that finds that it's a person who has a need to know. And so the two suggested additions that I made were first, a service provider named in a disposition order adopted by the court or retained by a party to fulfill the objectives of the disposition order. So that's one. And the other one would be a court diversion program or youth appropriate community-based provider to whom the child is referred by the state's attorney or the court if the child accepts the referral. And I think this is a small change, but I think that these are situations in which potentially we're violating the statute currently in almost every case, because we need to be able to communicate about what's going on in the juvenile case when a third-party service provider is involved at disposition or is involved in a diversion agreement. So that's the extent of the change that I discussed with Attorney Paul.
And these providers would be required to keep those records confidential, just as any other provider today would be.
That's right. That's correct, Senator Sears, and the same notice advising them of the consequences of redisclosing without authorization would apply as are currently provided in the statute. That's yeah, how I would view that.
Any questions for Bill, William?
Not seeing anything.
Okay, it sounds. Annika, any comment from the DCF on these two changes? While we have you still here.
Yeah, thank you. At first blush, I don't see any issue with those changes, but I would like to loop back to Lindy and also hear from Marshall Paul before I go on record officially, but they don't sound like there would be any issue.
They sound reasonable. But we will look at them 2 weeks now. Is there anything else on S33?
I don't think so. I'll remain available if there are any other questions about that.
Next witness is Mike Smith, the Deputy Commissioner, Department of Motor Vehicles. And I know Mike is I believe Mike is in the room. And
I am.
I'm sorry that I'm remote and not being able to see you in person, Mike. And Happy New Year to you.
Thank you, you too. And for the record, Michael Smith, Deputy Commissioner for DMV. So our concerns in regards to this bill is kind of twofold. It's from a compliance standpoint for the CDL program and from an operational standpoint of how to apply the changes. So I watched the video from a prior session where the discussion was surrounding individuals who have received a DUI conviction and then it was later amended to a negligent operation violation. So Eric's been sharing some modifications to the statute to try and figure out how the 30-day suspension period that comes with the conviction of the negligent operation, which is currently preventing them from moving directly into the ignition interlock. So in order to do that, language needs to be drafted that would either not withstand those points or acknowledge the fact that a negligent operation carries a 30-day mandatory suspension and somehow you are desiring to waive that suspension. It further gets compounded when you look at the negligent operation as a mandatory 30-day suspension, and that carries 10 points along with it. An individual may have other points existing on their record. They could have a prior leaving the scene of an accident, which has a 10-point violation, could be a separate negligent operation within the prior 2 years. Those will go through our computer system, and the system says you've exceeded the 10-point threshold, a suspension is due, code's negligent operation, it's going to issue it for 30 days, 90 days if it's a second. So somehow the statutory language needs to take into account those various factors. The other issue that I want to raise for the committee is from a CDL compliance issue. The department is required to make sure our CDL program is in compliance with the Federal Motor Carrier Safety Administration's regulations. And one of their big issues that they come at the state for is for masking violations. And basically, the way they see this is if you are initially charged with operation of a commercial motor vehicle over 0.04, so you're getting a DUI in a commercial motor vehicle. If that is pled down to a lesser violation, the federal government looks at the state of Vermont and says, you're covering up, you're masking convictions. The federal government desires that no deals or reductions be made in situations where commercial drivers are operating commercial motor vehicles. So to that end, in section 1201A1, it talks about 0.08, which I think is fine, but then it moves into 0.02 for school bus drivers. That is, again, your CDL portion. 1201A4 speaks to the flat out 0.04 in a commercial motor vehicle. So those need to be exempted from this to recognize the fact that commercial drivers are held to a higher standard, and then allow other drivers to be able to move into the ignition interlock right off, which is what I understand the committee's desires.
Well, yeah, that was really the goal, is to not penalize somebody who got a reduced charge to careless and negligent from DUI from being able to take advantage of the interlock system.
Right, right. So with some crafty language, I think we can achieve that goal.
Good.
I do have
Eric?
one question that is, I don't want to open up Pandora's box here, but I want to talk about vehicle inspections for a quick second. You know, and it's going to be pretty narrowly focused, so I'll just get right to the point. You know, my thought is that VNIs should be a secondary enforcement violation. You know, I don't think that people need to be getting stopped and detained by law enforcement just because they didn't pay for their vehicle inspection in a timely manner. I do think it's something that can and should be handled, you know, when folks go to the DMV or, you know, to renew their registration. If, for example, if their vehicle's not inspected, they can't renew, something like that. But do you have any thoughts on turning VNI into a secondary enforcement instead of a primary enforcement?
I do not.
Okay.
It's hard because, you know, right now, one of the issues that law enforcement experiences is all of our inspection stickers are yellow.
Mm-hmm.
So when you see it go by you, you cannot tell that that's expired, right? So it's not, excuse me, it's not the 4-color variation in the past where you could say, oh, red's this year, that one's yellow, something's wrong, right? So now one color, it's not easy for them to tell. I know that there is a working group right now that's looking at various violations within 23 to recommendations to the legislature for violations that should be considered secondaries. I can tell you that BI is in that conversation.
Okay, thank you. Anything else? Yep, Eric.
Eric?
So a couple of things, I guess. One, on the more technical piece, just to make sure we're looking at the same statute. I pull it up. I just want to make sure we've got the current version here.
Mhm.
Drives me. I'm looking at that, and that's where O2 is separated. I don't know if that just happened last year. I wasn't involved in it. But what year is it?
2022, this is the new one.
Yeah, no, funny. But so we'll figure that point out. But I guess the question I had was Senator Sears, and Mike was also mentioning the points issue, and I know that hadn't come up in the discussion previously, so it may be something that you don't want to change. In other words, as the example Mike used, you know, what came up, I think, with the case that Attorney Silver described was you had someone, as Mike mentioned, got charged with a DUI, but pled down to a negligent operation. And because of that, because the negligent operation carries that statutory minimum suspension, that person wouldn't be able to start the ignition interlock right away, the way someone who could is if they'd actually taken the DUI charge, right?
Right.
So that's the issue. But as Mike was saying, the negligent operation also carries some mandatory points. So let's say that same, well, different case, but doesn't really matter. Somebody's got 10 points for something else, and so if they get the 10 points for the negligent operation, that bumps them up into the suspension territory. They have so many points that they're going to get suspended. But that's not just on the basis of the plead down to negligent op. I mean, that's what causes it. But it's also because they did something else previously that they have points sitting on their record. So
Yeah.
you may or may not. In other words, it's kind of a different situation in the sense that it's not just a one-time first offender DUI person. You're talking about somebody who's got something else on at least 10 points on their record already. And so maybe you don't want them as a policy call, but I just wanted to put it out there for you to think about, is that maybe those aren't the same group of people that you would want to be able to get to use ignition interlock right away. You know, maybe because they've got a prior of some kind that already put 10 points on their record. Now you may want to, you may, I just want to be clear that that was a different group of people. So, you know, maybe you're only looking at the first time DUI.
Yeah, I think what we're looking at is really, if somebody has other things on their record that would preclude them from being able to access the interlock system, I don't want it to be an advantage to pleading to DUI when you could plead to careless and negligent. That's what I'm trying to have happen. There's no way the DUI should be an easier resolution for that person when they're offered a careless and negligent. It's just a matter of fairness. So I'm not concerned. If they have other points, that's really their problem.
So
I guess that's how I look at it. Now, maybe the rest of the committee looks at it differently. I'm looking at somebody who, you know, made a mistake, and for whatever reason, the state's attorney is willing to plead it down to careless and negligent. I just wish they would get the same opportunity at an interlock device as if they had stuck with a DUI, so they don't lose their job or whatever.
So do you notwithstand the points? I don't know how to legislatively draft it. I understand what you're after. You know, and clearly I think anytime we have an opportunity to get somebody behind the wheel with an ignition interlock as fast as possible, we should take that opportunity, right? Save roads. It's just having it right. Right.
Well, we'll ponder on that piece.
Pardon?
I said we'll ponder on the how to craft it piece, but I think I understand what you're getting at. In other words, do you want to give that? You say if they've got points, it's their problem. In other words, if they're going to get additional points for the negligent op, you in that case, do you want that person to be able to still get the ignition interlock right away, or do you want them
if they could under a DUI? That's what I.
That's right. What do you get points for DUI? Well, how was that? You know,
There's no points on DUI. It's just an automatic suspend.
so you would be able to get it under a DUI.
Correct. And, you know, conceptually, if the criminal was dismissed and the civil existed, you could get it on the civil. The only real factor that's problematic here is that neg op violation carrying points. That's what causes that problem. So.
But I think the interlock device has proven its success over the years, and so we should be encouraging its use.
That helps, Senator Sears. I think we got a handle on it. Thank you.
But, you know, I'm hopeful the rest of the committee agrees.
Yes. Well, I guess my question would be, Senator Sears, is I understand what we're looking for, and I don't have a problem. I agree. So what we're looking at is if someone was charged with DUI and it was pled down to a CNN, those
Yes.
exceptions would be available for the device we're referring to, right? But if someone just went and got charged with CNN because they were just from careless and negligently, and there was no plea deal, I mean, I think we have to look at, we're trying to address the plea deal, DUI suspects get it, versus the individual who was just charged outright with CNN because they were just not being a good person out there driving. I don't know if we should be looking at allowing those folks to be driving again immediately.
I mean,
Well, but the idea was with the interlock, so there's the connection with substance abuse and the interlock system. The CNN that was charged in the first place may be due to some other factor.
But if it isn't, that's my question. If they're just
Yeah, that's a good point.
being a bad person out there and driving over people's lawns and running through stop signs and people are ducking in the crosswalks here, whatever else, and I mean, those are things that I'm concerned about as far as.
And that furthers my,
oh, no, I was just, to your point, I mean, is there a way we can create two pathways for this where if it is a plea deal, it going from a DUI to a neg op, it's not going to be as harsh or harsher than the DUI compared to somebody just doing what Senator Morris is describing?
Yes, that's exactly the language we've been batting around in draft form does exactly that. It only applies to someone who was initially charged with a DUI and pled down.
Not
You're
sure
straight
if it's-
CNN,
Right,
wouldn't
okay,
get the advantage.
good deal, that works.
and that's where my concern came from, because if I was that individual making people duck in the crosswalks, and I've got a careless negligent or negligent operation already, so I've already got 10 points, I already served my 30 days. If I get another neg off, that's a mandatory 90-day suspension at that point, and 20 points on my record. So, but from what Senator Sear said, if they have prior points, that's their problem, so they wouldn't be allowed to get that conditioner on.
Right, I like the way Senator Sears is going with this, and I don't disagree with that, but my concern was just in the other areas.
Yeah.
Initial charge of CNN. Okay, thank you.
No, we can't, the problem, I think we've got a way to solve the problem, Eric. And the good news is you can think about it when you're in the sunshine down in Florida next week, watching the Yankees.
Yeah, my goal is to have it worked out by tomorrow, but you're right.
You don't want to be pondering this at the ballpark?
Right.
Wandering while you're waiting for the 20-second pitch clock.
Yeah, right. I'm liking all the new rules. It's sort of cool.
Yeah. Are there any other Department of Motor Vehicles issues with this bill? I don't think there are, Mike. Thank you.
Not at all.
At some point, I'd love to look at other issues regarding careless and negligent in terms of the ceiling, but that's a whole different matter. Okay, Eric, where are we at? Oh, no, I'm sorry. We have Trish Conti with the amendment from the Department of Public Safety.
Morning, everyone.
Morning,
For the record, my name is Trish Conti. I'm director of the Vermont Forensic Laboratory. I want to thank the committee for the opportunity to speak with you this morning about a minor change that our department has identified to Title 20 that we're seeking. My comments don't necessarily address the current iteration of S33, but we're hoping that what we've identified could find a home there potentially. So in section 1940 of Title 20, it pertains to the expungement of records and destruction of samples for the DNA data bank. The current language requires that we notify persons by certified mail that their DNA profile has been removed from the data bank and that their DNA card has been destroyed. Assuming that there's still a desire for us to provide that notification to the individual, we are asking that the certified requirement of that mailing be removed and allow us just to send those notifications via first-class mail. It'll save us a significant amount of time and costs that are associated with the statute as it stands now. Historically, a large number, upwards of 50% of these notifications are returned to us as unsuccessfully deliverable, based on updates to addresses not being made in the criminal history database that we look at to get those addresses. So in addition to wasting that money on postage, completion of all the certified mail paperwork does take a significant amount of time to fill out and complete and to put on these envelopes. So as it stands, it's over $8 for us to send out a single notification, whereas a simple first-class stamp would be 63 cents at the moment. So we're hoping just to have that certified requirement taken out.
Any questions? I spoken with Eric about this, and we felt it was pretty minor and made sense, but certainly something.
Yeah, I think that's pretty simple, straightforward, and helpful. I don't know if there's any other thoughts on it. Eric?
Just to complete the circle, what you mentioned, Senator Sears, I also circulated that to the court, the state's attorneys and defender general, and said if anybody had any issues, let me know. Nobody did.
Good. Well, anytime we can save money from certified mail, it's interesting how many you get back, though, that we were just talking about how to notify people of court that they need to make a court appearance, and how difficult it is today.
Yes, it is.
But I suppose, so that sounds good. There's no opposition, so Eric, why don't, thank you, Trish, appreciate it. And
Thank you.
Eric, why don't we see where we're at with the final few minutes, and looks like we'll get out early today.
I don't object to that.
You adjourned. I'm fine. Surprising.
More time to look at yes votes.
Yeah.
I can't believe the way we're too efficient here. Senator Shine, excuse me, I just missed. We set up an agenda, but we were very much too much efficient here today, much more than we expected.
Maybe we can jump on that hospital liens bill. I'm just kidding.
Yeah, I don't know. We're supposed to give a 24-hour notice. I noticed some committee got in trouble for not having a 24-hour notice to a meeting. Anyhow, Eric, where are we at?
I think that there's only 3 outstanding pieces, and we're sort of, it sounds like the committee's kind of moving toward resolution on 2 of them just now. One is the language from DPS on certified mail with respect to when someone's records are expunged from the DNA database. So the next draft could have that section that strikes the word certified. Does that make sense?
I do have one question. Domestic terrorism chapter, is that something that we're going to include in the new?
Yeah, that's also in the rough draft that I have going, that would include creation of a separate domestic terrorism chapter in the criminal code, because right now the domestic terrorism crime is, I always forget this, it's oddly located in a, and probably was just, shoehorned in when it was originally drafted, is my guess. I didn't work on it back then, but it's in, I think it's in a,
It's somewhere silly like conspiracy or extortion.
yes, extortion and threats. So I think the committee had discussed, and wouldn't it make more sense to take that domestic terrorism offense, have a separate chapter that locates it there, and then next year when if the S3 passes, then it would make sense to locate S3 in that chapter as well. It's a sort of connection to the domestic terrorism issue. So assuming everybody agrees that that's at least something that's worth looking at. That was the idea, to have that in the next draft too. Third thing is the DMV piece that we were discussing this morning, to clarify that when someone's charged with DUI and they plead down a negligent op, that they will be able to start the ignition interlock program without having to have the license suspended for 30 days. And just to clarify that last piece of that one, Senator Sears, I think I understood it correctly, that since someone who gets a DUI doesn't have points, I think you're gonna wanna say that if you, in that same situation, if you plead to a negligent op after having been charged with a DUI, that mandatory 30-day suspension doesn't apply, and you don't get the 10 points, right?
Right, yes.
That would,
Only in that situation.
correct, that would solve
Only.
the problem.
Right.
Or do you leave the points on the individual's record and just not suspend them for the 30 days? I think that's also a question the committee should answer, right? Because the issue is, don't suspend so they can get it right off.
Yeah.
Then I think the secondary issue is what you do with that conviction. It is a conviction for negligent operation, would go on the individual's record, it's gonna show there.
Yeah.
If the points are still associated with it, we would still post that as a suspension. But if the statute then says, basically disregard that suspension or notwithstand it, then we could issue the ability to get the
I think it's better, the notwithstanding language is better, because it's a unique circumstance where the charge has been, and they're only using an interlock, correct?
Right.
Yeah, that makes sense,
So-
because you wouldn't necessarily want the points to be disappear completely. You just
No.
want them to be able to start the ignition interlock right away.
Right.
Right.
Don't apply the
Yeah.
points right at that situation. Exactly.
Yep, that
So,
works.
so my question there would be, if a CNN conviction appears on their records and disregard the points, whatever, does that automatically invoke an S-22 that they have to provide for their,
They have to do that for the
The-
DUI.
but if it's pled down to the CNN,
They still have the civil DUI, which is how you get the ignition interlock, and that has the SR-22 requirement.
the SR-22,
Yeah.
okay, I'm sorry.
So they're gonna have to get that
Okay.
no matter what.
I agree. Yeah.
Eric, there was another issue that you missed. That's the juvenile records.
Yes, and I have one more too, but go ahead with that one, please.
That would be allowing, community-based services to have access to the records on the same basis that others get
Oh, right,
juvenile records.
yes, the language that William Gardell was mentioning earlier.
Yes,
Yes, and it sounds like they're probably, and I think Erica Radke was saying this too, do they wanna, should William send me that language?
well, I think if we send a copy to Marshall, if we send copies to all the usual suspects of your latest draft, and then they can make comments and come back the week after town meeting. If you
Thank
can
you.
get
That would
that
be
done
great.
by tomorrow.
Yes,
So they all would have it and then can respond to it if they'd like. And you can leave specific instructions to the days that you're at Yankee games to have them notify you those days.
thank you, I'll mention that in the email.
Senator Wells.
Maybe this has already been addressed and I just sort of missed it, but I remember, I think it was Marshall Paul testifying, so on page 9, line 4, asking that we strike delinquency.
That was gonna be my last.
Oh, perfect. Well, I'm so
exactly.
glad that I was able to read your mind.
You did, thank you. Well, please do, go ahead, no, I think you're right on the money with what the concern was.
Yes, well, and that I was wanting to, and I have a couple of others that I want to bring into the room, but I wanted to start with that one that had already been testified to, so I just wanted to make sure that we were considering that.
Right.
Okay. What was that?
So in section 11, section 12, subsection 2, Also, for the purposes of this section, prosecution for a misdemeanor and prosecution for a felony shall include delinquency and youthful offender proceedings. Marshall Paul agreed to youthful offender because that already is sort of in the criminal court system, but said that delinquency should not be included because that is within the family court system and would create.
Yep.
Yeah. So I just wanted to remind the committee that that was an issue that we hadn't yet discussed.
That's fine with me.
Yeah.
Fine with me too.
To strike the reference to juvenile.
Yeah, delinquency and we would just say shall include youthful offender proceedings.
Right.
Yeah.
And then I also, this committee has had a lot of conversation about the sort of problematic, overly broad definition of stalking. And I wonder if the miscellaneous bill would be a place to try and define that more clearly as to what we mean when we are talking about stalking, so that it is both inclusive of non-familial dangerous stalking, but maybe not inclusive of neighbor disputes.
Sounds like a fairly involved discussion. And so I guess my only comment would be we're running up on time. I don't know how Senator Sears would feel about that.
Yeah, I think it's a little. I agree that we're running up on time here, and what we could do is ask the Sentencing Commission to look at that issue.
That seems perfectly reasonable to me. I just know that we've talked a couple times about trying to redefine that more.
Well, I think the issue of is it sometimes these little neighborhood disputes, though, I can remember one where whose tree got cut down. They ended up in a huge dispute in Manchester that somehow I got involved in because I was trying to help constituents. If the tree is on your property, the limb was on somebody else's property anyway. Sometimes these things get pretty dicey between neighbors, but if we're looking at what I think we're looking at is how to look at stalking. If we can express that and get something to Eric, I don't have any problem with the Sentencing Commission being asked to report back on this.
That's certainly fine with me, and I certainly want to be clear that I'm not suggesting that neighbor to neighbor disputes can't ever rise to the level of dangerous stalking. I certainly have a constituent whose home ended up getting shot because of a neighbor dispute. So I certainly do not want to make any definition that would say neighbors can't stalk each other. But I did hear from someone, I can't remember who, because we've heard from a lot of people that sometimes these lower level non-violent neighbor disputes might sort of plead to say, fine, I don't want to be near them anyways, I'll just stay away from them. And so I just wanted to be cognizant of that, but I'm happy to have the sentencing project do it. I had one other question, I think, for Eric. So our oaths, like in this bill, the oath of the petty juror, are those what people are supposed to say in statute?
I'm not certain.
Okay, because I see it here, and my question about it, given our constitutional separation of church and state, is if it is in statute, if it should actually read under the pains and penalties of perjury rather than so help you God.
What section are you on?
Section 10, beginning on line 4, which is page 7.
Yeah, oh yeah, so that is in statute, correct. But I think that's a policy decision for you as to whether you want that to be in there or not. It's not I don't think, a generic reference to religion as opposed to a particular religion necessarily is a First Amendment issue. But it certainly is a policy decision whether or not you want that in there.
I would be interested to know how long that's been in statute.
I'm fine with changing it to under the pains and penalties of perjury.
Still on S, no way on there, 33,
33,
page 7.
yes. Section 10 starts
Isn't
right.
somewhere else in law, Eric, people are given the right to say something different?
Yes, there are times when it's either or. Or, that's sometimes, under pain of penalty of perjury, or like you can swear or,
But
Affirm.
even if you say, so help you God, you're still under the pains and penalties of perjury, right?
yes.
So if you put or, doesn't it kind of confuse that? Sounds like or you're saying either your God will judge you or the court will have jurisdiction to judge you.
I don't have a problem just leaving it there.
Well, I'm just wondering if,
I will say that one thing I just found, so there's a number of statutes, quite a few, in the oaths chapter that all say, so help you God. So it would be odd to change one.
I mean, I would also advocate for just changing all of them.
I don't think we should do that in miscellaneous judiciary bill.
that's gonna be a more involved discussion.
If we're gonna change them all, I think we'd be,
All right.
All right, interesting, so there's another statute, another section that's, I think, relevant here. A general statute about all these oaths, because as Senator Bohofsky was just mentioning, this is the oaths for editors, criminal cases, but there's a number of other statutes, grand juries, et cetera, various oaths, a number of sections. And then there's sort of it looks to be sort of a catch-all section that says affirmation. In the administration of an oath, the word swear may be omitted and the word affirm substituted. And the word so help you God may be omitted and the word under the pains and penalties of perjury may be substituted.
Okay, so it's possible in any of the instances to choose,
It's optional.
Correct.
which is the way we do it on Senate.
Yeah.
Yep.
Yeah, I guess, and I'm happy to have a larger discussion about it. I just generally, the way it's printed just rubs me the wrong way. Given that we're not, we are supposed to have a separation of church and state. So having this sort of enshrined in statute.
I think what Eric's saying is it's enshrined, but wrapped around with that either or language.
And correct me if I'm wrong, I think the point is saying that it shouldn't be instead at all.
Yes.
Is the gist of it.
I'm just gonna, again, this is miscellaneous judicial practices.
I was hoping it was gonna be a miscellaneous, but it seems bigger.
All right.
This seems like a bigger issue than the miscellaneous. Because it's throughout, I know there were voter oaths that we take too and things like that. I can't remember what I just pled to when I filled up my absentee ballot.
I'm happy to not do it here. I'm recognizing it's a bigger issue than I had anticipated.
Are there other issues with the bill before we, I always like to this be the last bill that comes out of committee because you never know what's going to come up. But the House will have an opportunity to add to it as well.
Senator Sears, so are we, I think so this is on the agenda for tomorrow at 10:30. So should we look at a rough draft tomorrow based on the conversation that we've had today?
I know.
I think maybe if there's time, Peggy, you wanted to do your, everybody wants to talk, a number of the members of the committee wanted to discuss hospital liens. And I don't know if you can pull that together, Peggy, or not.
So do you want me to take 33 off and try for hospital liens? It may be tough to get them tomorrow, but I can try.
We can try.
Okay, so take 33 off.
Yeah, because I think we pretty much are there. And I don't want to vote on it tomorrow. And so we would do it 2 weeks from today. And if we can't do liens, we could have continued discussion on S16 too. Reminding us that Senator Norris won't be here tomorrow.
Well, Senator Norris may be here tomorrow.
Oh,
I didn't realize it was at my request that Bishop Coyne is coming in along the Vector, and I guess I would feel somewhat. So I may be missing my important meeting with tapping trees tomorrow with the governor. So,
well,
and if we're on the floor again and represent, I think is much more important place to be. So
I will be remote tomorrow, though, just as an FYI.
okay.
I'll be
I
joining you
will be-
remotely, but not in Bennington.
Okay.
We'll be here from 4.
Well, did we schedule, we have tomorrow also S89, right, Peggy?
We do for 15 minutes.
Yeah, that's all we could get Katie for, so. All right, sounds good.
what's your suggestion?